is 2:01, and Michelle, thank you for being here, and thank everyone for coming on. I think that's great. We have a great turnout today. This is fantastic. And we will be recording this, and I'll be releasing it. A number of people have asked about that, so we are going to make sure that the video will be available for everybody who wants to see it, especially if they'd like to review things that we discuss in our conversation today, or share it with anybody that would like to know. But to kick off, Michelle, I'm going to introduce you. You've been in the industry for 20 years. You are the lead member on Fidelity's tax and retirement research team, and you have a focus on estate planning and retirement trends. You have been the director of corporate tax Fidelity Investments for the last 10 years. You were senior manager at taxation at Ernst & Young in a past life, I take it.
Yes.
And you're a member of the Chartered Professional Accountants of Ontario. So I'm very pleased to have you join us today. And I want to thank you. I want to thank again, Alex Cabrini, my wholesaler who helped arrange the meeting today. I think Fidelity has been a pretty good partner, and your funds have done very well over time. So I'm pleased to continue to use them. And I want to thank you again for joining me. We want to be mindful of time today. So we've decided to opt for the like I've done in a similar webinars, conversational. We're skipping over any formal thing. We're just going to chat a little bit about what sort of mistakes and things that people should look out for when it comes to planning for estates and passing on wealth to the next generation. This is a common now and reoccurring conversation I have with people. People are worried about making sure that their assets get to the next, to their kids, to people they'd like to donate to, intact and preserved as much as possible. So I'm going to kick it off and ask you directly, Michelle, what do you think are the worst ideas when it comes to passing money to your kids, or making, especially if you've got multiple kids or maybe a blended family? What is the biggest mistake that you think people are making, either in focus or just generally?
Well, I think in general, we as a society, we're uncomfortable talking about death. We're uncomfortable talking about money, and we're uncomfortable talking about taxes. And that is what estate planning is all about, right? So first of all, it's getting over, the biggest mistake is not being comfortable with those conversations. So getting over that hurdle, and then talking about it between partners, and then talking about it intergenerationally. And so there's no surprises on death. It's what was intended, and then it's carried out the way it was intended. And really starting having these conversations as early as possible. I often make a joke, like the best time to plant a tree was 20 years ago, but the next best time is today. And, as we're talking, Adrian, well, the people who are signed up for this session, they're already agreeable to having these types of conversations. So it's a little bit like preaching to the choir here.
Okay. What do you think people tend to gloss over? There's a lot of different stories of mistakes that get handed over in passing down assets from one generation to another. There's things like cottages, or there could be it's not just monetary assets. Sometimes we're talking sometimes about houses and physical things as well. What kind of mistakes do you think people make? Obviously, the conversation is the ground level. Who wants what and how it should be divided. What kind of mistakes do people make when they're doing that?
Well, it's the perception of, is it fair between, and I'm just going to talk from one generation to the next, especially when you have multiple children. And so is it perception? Is it fair? Is that, and then is it, and there's other pieces too. Let's think of, okay, well, mom and dad have come up with their plan of what they think they want to do. And then, okay, they would write it in a will, and they're working with a lawyer. And I think you really get what you pay for. That will should be updated at a minimum every 5 years. What happens is that there's changes in estate rules, there's changes in legalese, I'm going to use that as a term. There could be changes in taxation. There's changes in your own family situation of how you want things to be allocated. And then it goes on to, well, and then is it carried out the way you intended? And you could do things like what goes in a will. Sometimes people have multiple wills. Some people have designated beneficiaries. So then you're talking about, well, how is it to be allocated? And you're looking at fairness ways of doing that. And then is it perceived fairly by the beneficiaries? And you don't want to have surprises. You had mentioned when we first started talking, it's about the family cottage. And I think this is a pretty key example to talk about, because it's not like a mutual fund where it's money, but a cottage, there's an emotion to it. And I can use my own parents as an example. We have a family cottage, and just the emotion side of it is that they would like to see that cottage pass to my brother and me. The truth of the matter is my brother and I aren't really interested in owning a cottage or maintaining a cottage, but it's an awkward conversation. And as much as we've tried to say, like, this isn't really where we're landing, they don't hear us. And I hear this story again and again. I'll take this. So there's the conversation piece, as well as I'm going to go into a bit of a taxation side of things. People they don't necessarily think about, well, I pass away and what happens from a taxation standpoint. Well, I'm deemed to have disposed of all of my assets. And let me talk about the cottage aspect. Well, my parents' cottage they bought the land in the 60s. They built on it in the early 70s. So this is the tax cost of it. They've done renovations to it, additions. What else has happened? Back in the 70s and 80s, you could have 2 principal residences. And then in the 90s, where I'm getting into details, where I'm going is that calculating the tax cost of that cottage is very complicated stuff. And I'm a tax accountant, right? I want to make sure that I have accounted for every dollar that's gone into that cost, because I want the cost to be as high as possible. So I'm reducing the gain. The fair market value on death, on disposition, deemed disposition, that's easy to calculate, because you can get a real estate agent to say the fair market value on such and such a date is X amount, but you want to go into the cost. And you're going back in records for decades, literally. And I keep reminding my parents, like, this is something you should be looking at. And they don't hear it.
So is a bit of advice that maybe should come up, and I'm going to just remind everyone, if you have questions, there's the Q&A button at the bottom. You can send us a question that way in case you wanted us to touch on anything. But, if you're having conversations and you're having conversations with your kids and you have an asset that you thought you might pass on, doesn't matter if it's a boat or an old car or it's a cottage or it's an apartment. Maybe you've got like something else, I don't know. And your children don't want it, or the beneficiaries are sort of saying to you, you don't want it. Is your advice then that maybe they should consider selling it now? Is there benefit to selling it now versus letting it roll into the estate and having it dealt with by the beneficiaries?
I think it cleans up the estate quite a bit. It makes it easier to administer. As a blanket statement, would I say, yes, you should sell it now? But give it some consideration, because you're trying to simplify the estate. And it's up to the executor of the estate, and it's actually the trustee, and what everyone calls it, the executor, who's settling the estate, who has to sell the properties, who has to distribute the assets, and who has to do the final tax returns. So if you're in this situation and you know that the beneficiaries probably don't want it and would prefer the cash, heed their advice. Sell it now. Clean up your estate. You have the cash. You can invest it. Do what you want with it. There's a lot of different options that you could take from there.
Okay. So conversations are central to getting your estate plan in order, because it clears up mistakes or, I guess, assumptions that one generation may have about this is the way that this should look, and meets the reality of how another generation may perceive that. So I always thought I was going to get this. The other child says, I didn't think about that, or I thought it was going to be this way. No one's talked about it, and it just creates strain later on. It also clears up whether there's costly assets. You also touched on, though, obviously wills are central to this. You should have a will and you don't want to die intestate. So how often do you think a will should be redone? We've sort of, and I'll say we have advised people, it's kind of like every 3 years because things can change. And I think if you're getting older, though, that seems a bit burdensome. If maybe every 3 years, not a lot's changing. So what should motivate people to make a significant redo on their will? And then maybe what should just be an average caretaking number of times to redo their will?
So anytime there's a life change, so a marriage, a divorce, and that could be within the couple as well as their adult children. There could be new grandchildren on the landscape, if you will. So you're looking at life changes. The thing that I'm cautious of is that you don't know what you don't know. So there could be tax changes. There could be those legalese type changes and there's new estate case law that's being revised all the time. There's a lot of litigation that goes on with estates. And because of that, it changes the perceptions and people change the wording, the standard wording to be more clear for their intentions. And that's being continuously updated. So I like to say every 5 years, just brush it off, give your estate lawyer a call and say, is there anything we should be thinking about? And an ounce of prevention is kind of worth a pound of cure.
Okay.
And what else? We know statistically about 50% of Canadians do not have a will, which means 50% of those do have a will. And we do a retirement survey every year, which is for 45 and older. And the same statistic holds true for even that age group. So it's the importance of having a will and updating it about every 5 years. It's important.
Okay.
Thinking about, and we were talking earlier about the assets, and I would like people to come away with, no matter sort of where you are reviewing, well, what are the assets that you own?
Yeah.
And how would you like them to be distributed? Do you want them to going back to the cottage idea, do you want the property to be distributed intact as a real property? Or is the intention to sell it and then the cash would be distributed?
Yeah.
And there's depending on the situation, lawyers can tailor the wording of the will to reflect what your intentions are.
Okay, I want to jump in on something there because I've got a good question that's just come up, and I want to actually follow up with an idea, because one of the things that has, I think, transitioned in our society is parents are obviously generationally, we live a lot longer now. I am a keen observer of Canada's housing market. So let's say you are a number of people wish to help their children now get into the property ladder. And you're looking now at prices in Toronto in excess of, 1.2 million to 1.7 million for starter homes. So a lot of people would like to pass assets or gift money to kids to help get them started. Is there any advice that we would want to share? So instead of putting it into the will for tax reasons, what are the tax implications if parents want to give money to kids now to help get their life going?
Right. And especially true in the GTA, where it's a high cost of living area. And if your children are in the area, we do want to help them get established, buy that first home, give them a little bit for their down payment, what have you. And there's that emotional tie that we were talking about earlier, that you're giving your money today to help your children. And so that feels good. So there's lots of good reasons to do this. Now, if say I'm selling investments to fund that gift, I could be selling those, like if they're Fidelity investments, I'm selling them at a gain. And so you're triggering, realizing a capital gain today. It means I'm going to pay taxes on that today. And then the next step of that, well, once I've given that cash to the next generation, they are under no obligation to return that to me should I need it in my own end of life. So it's being sure that I'm setting aside enough for that for my own future end of life, for my own retirement, right? So planning ahead. The third piece of that is once you give that money to children, to adult children, for whatever reason, there's the potential that that becomes part of the children's marital property. And about 50% of, depending what statistic you read, of marriages end in separation and divorce. So that could be part of the marital property that is then divided. So that's another consideration too. So it's thinking about that the whole, it was that three things: the taxes you pay today, your future retirement, and could be marital property, trifecta there.
The marital property one I think is interesting, and I want to focus on that a bit more, because I think for a lot of people, it doesn't matter how much they like their in-laws, their children, who their children have married. They are just as conscious of the fact that 50% of marriages could end up in divorce. Their marriage may have ended up in divorce, and now they're helping their kids, and they're worried. They've worked their life for these assets. They're now gifting them to help the next generation progress in some way. What kind of advice to reduce the entitlement by spouses to assets that have come from one side of the family? Is there anything that they can do to protect those assets once you've given it over? Is there any protection that can be offered, or is that is it always going to be out of reach of that kind of protection?
Well, I'm struggling a little bit.
So I'll say it again, and this time in real English, as opposed to just leaving my brain to do it. If my wife and I get divorced, and my father has gifted us some money to help with a house or help with something, and as you point out, it goes into the marital assets, my father would say, I've worked my life for those assets. That it was there to help you, not to help them when you split up. Was there a way that could have been structured to protect that money from a divorce, or is it always going to end up as a joint custody?
Right. So there's a lot of lawyers getting rich over this, and the litigation that goes along with it. And I'll tell a personal story of a friend of mine who was she is the wife, and her in-laws gave them a down payment for their home. And the in-laws asked that she sign a document that said if the marriage dissolved, that she would repay her 50% of the gift. So I was like, first, she was, there's two prongs here. I'll talk about the emotional, and I'll talk about the legal side. So I talked to a friend of mine who's a lawyer, so the legal side, and I'm like, is there any validity to this? He said, potentially, yes, if it was drafted up correctly, cross your T's and dot your I's, there is a way to do that. Now, I'm not a lawyer, tax accountant, but I spoke with a very knowledgeable lawyer who said it's possible. But on the flip side, what this caused was an emotional rift between my gal pal, her husband, and her new husband. And people remember those early years of marriage. They're hard when you're trying to navigate those early years. So it's a rift there, and a rift with her in-laws. So my advice on that is that if you're that concerned about giving the money to your in-law or your child-in-law, that you probably shouldn't be doing it, because the emotional toll isn't worth it.
Yeah. No. I think that's sensible. Okay.
Yeah.
So let's talk a little bit more about giving money to kids. There's some other ways that people have tried to work around taxes or try and simplify estate planning. One of them is adding children as either, holders on property, make them joint on bank accounts. What's the tax implication of that? Is there taxes that should be considered? I mean, I've always been surprised that you could, in theory, the idea I can add someone on to simplify the management of an account, but I can't imagine that Revenue Canada doesn't have a view on assets that have yet to be sold, but might bypass someone. So what happens if you add someone to your make an investable account joint? What are the tax implications there?
Okay. So what we're talking about is setting up, and I'm going to use an example for a investment account. It's being set up with joint tenancy with rights of survivorship. So joint tenancy means that it's just the legal title is in both names. So I'm going to use mom and adult son in my example. Now, from a tax perspective, what mom should be doing is she's disposed of those assets inside the account and gifted them to the son at fair market value. Very few people actually take this extra step because with that disposition, they are realizing a gain, which means they're paying taxes today. Now, the reason that they're doing this is when you have a joint account with rights of survivorship, it could be outside of the will and outside of probate, which is what they're trying to achieve. As well as there's the administrative ease that, well, this joint account, the son can help out with if mom's unable to do so. So people typically don't go down that pathway of the taxes and doing that. So they haven't actually avoided the probate implication. So without doing that, so they haven't saved their probate issues. And what else was I going to say? Oh, when mom's put adult son, the legal title on this account, well, the son could be making changes. The son could take money out of the account that mom maybe didn't want him to because he's on legal ownership with the account. And also the account now becomes part of the son's, it's part of his assets. He legally owns them. So if there's a creditor dispute where creditors do a title search, and these things actually happen, I'll tell a story in a bit, then those assets could be seized by the creditor, as well as they could be seized, it could become under dispute under a marital breakdown, which we've gone into detail. In theory, though, the marital issue is less at risk, although the litigation around this is changing all the time. The reason I'm saying it should be less at risk is because it's solely in the son's name and it hasn't been commingled into marital assets. But as I said, there's litigation going on all the time. And even if, say, the estranged wife is not successful through litigation, it costs lawyers' fees. It costs animosity between everybody. I was going to tell a story. There was a lady out in Burnaby, BC, and I don't know, sometimes I think people hear these stories and they take them and they're like, oh, this is a great idea. I'm going to take my principal residence, put it in joint name with her son. And so she's going to avoid probate on the principal residence. And well, principal residence on death, there's no taxation on that anyway, because a gain from a principal resident is exempt from tax. So she didn't get that advice. She didn't tell her son that she was doing this. Her son ran into creditor issues. They did exactly what I said, a title search, and the creditors put a lien on the house. And then mom tried to unwind it and went through the court system. She lost. And then the courts found that the creditors did have a claim to the house, only 50%, because the son only owned 50%. But because it became like this big media thing out in BC, that the creditors decided that they would hold off on actually seizing the asset because they could have forced mom to sell sell the house. You can't sell half a house. And so like these are real issues that happen. And I really want to stress the importance of getting legal advice, specific advice about your situation. I would have said if depending on the time of year on the cocktail circuit, but a year after a pandemic, that's not happening anymore.
It's just people are so excited for the cocktail circuit right now, Michelle. You can.
Maybe it's the Zoom cocktail circuit as you take your coffee.
Yeah.
But so it's misinformation or half correct information, and then taking that and applying it. Well, I think through our conversation today, we're giving people ideas, but really taking these ideas and then before you talk to the experts before taking action.
Yeah, I want to seize on the idea about sort of the sort of half-formed information that moves around. Probate is mentioned to me, if there's a day of the week that ends in Y, probate's the number one concern that people are worried about. But my impression of probate when I speak to accountants is, what are you worried about? The taxes that will be applied to the estate, the taxes that will be considered for, your RIF and your LIF. If those things have no one to go to, a spouse to directly hand them over to, they will be deemed to have been sold, and taxes will have to be paid on those assets. Taxes will be paid on the carriage. All of these dwarf probate. So I'm sort of not so worried about probate, but people get really wrapped up about probate. Definitively speaking, how worried should you be about probate?
I don't think you should be worried at all, actually. On $1 million estate, probate would be $15,000. And what it's doing is it's giving the executor the right to be distributing those assets under the will. And there's ways that you touched upon that maybe our viewers aren't aware of, but where you have an RRSP, a RIF, a life insurance, TFSA that has a designated beneficiary to those accounts, those funds transfer to that designated beneficiary directly. So they're outside of the will. So it's the assets that are inside the will that would be subject to probate.
This is an interesting one that we've just had this come up. Someone's passed away. We've had a look at what was on the forms. Most people have their spouse as a beneficiary. In this instance, there was no spouse. There's just other living family. The beneficiary is the estate. So the LIF and the RSP will go through that. I'm getting good. We got some questions here, so I'm gonna flip over to that in just a second. But had they put down their sister as the beneficiary, they wouldn't bypass the taxes. The taxes are still going to be paid, but they could have bypassed the probate. Exactly. And it's a small thing, but it's still a notable thing that should be paid attention to. Probate can be bypassed, even if you don't have a direct spouse to leave your RSP, your TFSA to, but you can bypass the probate, but not the taxes. I'm going to go. We have a great question here from Margaret and Bill. They say their son lives in the United States. We understand that naming him executor is going to lead to complications. It's also been suggested that they should set up a dynasty trust. Do we do that in Canada or where he lives in the United States?
Okay.
Now, I think as well, and I'm going to add just some color here. I know that these two also have an additional child who lives here in Canada. So one child is being being selected to be the executor, but that person is not nearby.
Right. All right. So I'm going to go back, start with the beginning. So typically what happens is you have two spouses and one spouse passes away, they roll over their assets to the surviving spouse. And then on the death of the surviving spouse, then it gets distributed to the children. And you're looking to the executor to settle the estate. What happens on that death of I'm going to say the surviving spouse in this situation is the assets form a trust. And the executor, the estate and trustee, is the technical word. I'm using the word trustee because there's a trust that's formed of the assets on death. And if you have a trustee who's based in the US, well, then that deceased trust becomes a trust in the US because the trustee is based in the US. So that's why we don't want to have someone from a different jurisdiction outside of Canada as the trustee. Okay, so there's a big explanation. So as long as the other child is in Canada, then that's a good solution. And as long as the children are in good, if you know your children better than I do, obviously, but you know how they will work together and they'll probably do things together anyway, right? And and I think there's also the point of explaining to the one child who's not the executor and the one who is, this is why we made the decision the way it is. And now a dynasty trust is outside my area of expertise, so I'm not going to speak to that. But when I am going to speak a little bit about what we talked about, you're deemed to have disposed of your assets on death. And there's rollovers between tax deferred rollovers between spouses. So I talk about this more on the death of the surviving spouse. There's taxes to be paid. But then that inheritance, the after tax estate, well, that can be distributed to the beneficiaries and they receive that tax free.
Okay. So just to circle back to the question we just went over, your advice is that they should not use the child that is in the US based as the executor. You strongly caution against that because it moves the estate to the US for tax reasons. And
Right.
I think actually some of their taxes there are less favorable than ours.
Right.
And at the very least, it's going to open up new costs that the estate will have to bear as part of it.
They may not even end up paying taxes, but they might have the administrative burden of having to file a trust return in the US because the executor is based in the US. And it just makes it overly complicated.
Okay. And so the other side of that is if there is for no other reason that they have to go with it, that is something that they should be aware of if they have to go down that road. Let's ask about someone's asked us about, or Carol's asked us about an alter ego trust. Can you discuss what that is?
I do know at a high level, alter ego trust. And typically where we would see this is someone, maybe we should just take a step back and say, well, what is a trust period? And the common knowledge.
That sounds great because I have that written down as a question to talk about. What are trusts and when does it seem like a good idea to use them? Because they are a buzzword in their own way. Estate books love to introduce the idea of trusts. Personally, I think very few Canadians benefit from a trust because they're complicated legal entities with high costs. So why don't you give us sort of a rundown of what we should know about a trust then, Michelle? That would be great.
Let's do 101 on trust. So a trust, you have a donor or someone who is the settler. Sometimes those words get interchanged. That's the person who's putting money into a trust. And then we have a trustee. The trustee is someone who's responsible for carrying out the functions of the trust. They would make the investment decisions. They may make the who gets the money from the trust, when's the trust to be wound up. And then you have the beneficiaries of the trust. Those are the ones who'd be entitled to either income or capital from the trust. So there's three different people. There's two different times that are typically when you'd set up a trust. During your lifetime, which is inter vivos, Latin word, or you could set it up testamentary, which is on your death, and it's usually set up as a way through the will. Now there's formal trusts, and those are the ones that we usually talk about here and when we talked about estate planning. And the formal trust is exactly, it's a legal document, which means you have to have a lawyer involved to write up what is the intention of the trust, who is the donor, who is the trustee, who are the beneficiaries, and it gives some guidance to the trustee about what can be distributed to whom and when, under what circumstances. So you can do this for a lot of different reasons. But if you are listening, it sounds complicated, right? We're talking with lawyers, which means it's going to be expensive just to set this thing up. And then you need a trust return to be done every year, which means you need financial statements, and a tax return, which means you need accountants. So then there's ongoing costs. As a general rule of thumb, you're looking at $1 million
to make it worthwhile.
To make it worthwhile. Now, there's other reasons why you might have it less than that. Thinking that maybe you want to set up a trust for a beneficiary who's disabled. It could be you have a spendthrift beneficiary, meaning that you give them $1, they'll spend $2. So you want to take over time that they're not spending their inheritance too quickly or something like that. But just a general rule of thumb, we're looking at a big number because it's expensive to set up and maintain.
Yeah, and I think this is one of the just to chime in on that. It's one of the reasons that trusts, just we've reviewed them several times, and most of the time it doesn't matter. Is if you're creating a trust, you're really creating a separate legal entity. Is there a reason why you need to create an artificial person for this money to guard against either legal attacks, or because you don't want someone to get all the money right away, or as you say, because they might be disabled and they need that money managed over a longer period? And there's particular trusts that are connected to all of those things. Do you know what an alter ego trust? I shouldn't say it. That sounds very very direct. But I'm curious to know. Can you give us some insight as to what an alter ego trust would be as one of those trusts?
Yeah, so we've gone over just your basic trust structure. So when you set up an alter ego trust, it's a separate entity, and say I'm setting one up. How it would work is that I would transfer my assets into this alter ego trust, and then I would be the primary beneficiary for my lifetime. And then what happens is then after I pass away, the beneficiaries transfer to my children. So this is a way that allows me to put my money into a trust so it's set aside, and that I know how it's going to be transferred on my death. So this is outside a will. So often we see this where people are concerned about privacy because they want to have their assets. They're in a trust. It's a private setup. I'm going to go back to what do I mean by privacy? A will that gets probated goes to probate court and it becomes a public document. So I, for $20 administrative fee, could go to probate court in Ontario, Toronto, and get a copy of, say, Rob Ford's will. So people don't want to have that as a potentially that their will could be a public document. So they might set it up for that reason. Some people like to have a family trust so they know that their grandchildren will be cared for. Sometimes we see it in a spousal trust, especially when you have second marriages, is that, well, you want your surviving spouse to be cared for during his or her lifetime, but the capital of the assets to go to the children from the first marriage. So there's lots of reasons you might want to set it up, but they are expensive. So it's a little bit of caveat emptor, beware.
There's something that goes along with this too, and we haven't really talked about it. It's the trustee, the person who's going to manage that, which has to be someone that can potentially outlive the person for whom the trust was initially created for, which is another expense that should be considered. Trustees often do get fees for their time, in addition to the lawyer's fees for setting up and the accountant fees that will be required for the filing. Trusts are taxed at a very high rate. They're taxed at the marginal rate in Canada, I believe. So they're expensive on that respect too. And it's one of the reasons that I think there is a growing business among some of the ultra wealthy in estate planning when it comes to trust, because there can be now corporate trustees that, it's the kind of thing that sounds like you'll end up in the Panama Papers eventually, but there is an aspect of that. But it was a great question. And Carol, I'm just going to be mindful. If you still would like to ask questions, you can just click on the Q&A button. We've had some great questions so far. I'm going to move ahead here. I want to talk a little bit about, we've talked about giving gifts to kids. We've talked about making accounts joint. We've talked a little bit about some of the common mistakes and introduction ways that you should be planning your estate. I want to talk, and we talked about cottages, about big assets like cottages as well. And I think that can assume to anything else. If you own art or anything else that could be considered valuable, those are conversations that need to be had and understood. So I'd like to ask instead about gifting and charities. Let's say you don't have anyone that you're going to leave it to. You've got no kids, but that money is still going to go somewhere. You've probably outlined maybe some charities that you might like to help. Maybe you've got some more distant relatives that you'd like to gift money to. They may be at the same age, maybe nieces, nephews, that kind of thing. Is there anything else that we should think about? What if you want to give money while you're still alive on an ongoing basis? You're not going to create a trust, but maybe you want to create some kind of foundation or something like that. Is there any advice that you can offer around that tax-wise?
Well, I'm thinking tax-wise, when you donate to a charity during our lifetime, we're limited to the amount of the non-refundable tax credit you could take, that donation tax credit. There's no limit on death, so you can deduct that or take a credit for the entire amount. And as well as if it's given through the will, it could also be claimed, that donation tax credit can be claimed on the final return. So that's an important consideration to take into account as well. Well, it was a long question, Adrian.
That's my specialty, is I talk long enough that you forget what the beginning of the sentence was. I guess, so I'll jump to a point here where maybe you can give some more clarity, because it'll be a shorter question. We've had instances where someone would like to leave money to a charity.
Right.
And we might say you can gift it in kind as part of the estate, and it will be tax efficient for the benefit of the estate. You can leave an asset like a stock or a mutual fund, and receptive charities are all over this today. They've got pages if you'd like to give in kind right now, or if you'd like to give in kind after death, it can all be set up. Is there a reason why we wouldn't do that? Or is there always a reason why we should?
Okay, so if you're sitting on securities that have an embedded gain, capital gain, if you sell those securities and you trigger that gain, and then you donate the cash, well, let's go through the steps. You sell securities at a gain, you've triggered that gain, you're going to pay capital gains tax, and then you donate the cash, you can get a non-refundable tax credit. Okay. If you donate securities in kind, which I mean the mutual fund units or the common shares of ABC company to a charity, that capital gain on those securities that are donated is eliminated to zero. So it's a very tax efficient way to be donating. So you're not going, well, you will trigger a gain because you've deemed disposed of it, but the capital gains inclusion rate is zero now, so you're not paying taxes on that gain. But you can still get a donation receipt for 100% of the fair market value of those donated securities. So that's an important it's an important thing to think about. And a bit of a cynic, or a cynical comment perhaps, but when you see a wing, the Michelle Munro wing of your local hospital, most likely I've donated securities to that hospital. And so I'm not paying my capital gains tax on those donated securities. So that's what a lot of people do to avoid the capital gains tax. And you could do that during your lifetime, and you could do that through your will. So we're going to donate these securities that are at a capital gain, and that's how it gets achieved. And even if it's done through that will, that capital gain is eliminated on the terminal return.
That's great. It is 2:45. We have no more answers or no more questions to have been offered. So I want to wrap up. I want to review very quickly what we've discussed. Then I want to just point out a couple of things, and then we'll let everyone go. And I really want to thank you again, Michelle, for joining us. But I think the big thing to start off with is your estate plan is all about trying to, I think, in fairness, make sure that what you have done in life closely aligns with your values and where you would like it to go. And the way that you're going to achieve that is to start with things like wills. But your recommendation is obviously that we should sit down and have those conversations with the people we intend to leave money or gifts or assets to, so they understand what they're going to get, so they can give feedback about that, so that they understand that it is fair. There should be transparency. There should be a lot of openness, and you probably want to see things like lists of the assets. As a funny aside, I did know a lawyer that once said they'd worked out a will, they'd gone through all the assets, and then they said, was there anything else that needed to be identified in the will specifically? And they go, well, what about that Picasso over the fireplace? And it just hadn't occurred to them, just it was a painting in the fireplace. But of course, even your art can be something that you may want to discuss with people. That's, it's one of those things. If you want to give money to your children, or if you want to bring them on and share, bank accounts with them, or help bypass probate or help with the management of things, but you have any concerns or there's any reason why you should be concerned, really, it's probably better that you don't do it. You know, if you want to gift the money, but you're worried that a spouse may divorce and that's going to split it up, probably better that you don't give them the money. I think that was a fair summation of what you were looking at there. Trusts, they do work if you've got enough money and if you really need to create it. But for the most part, they're expensive and they require a lot of forethought to make it work. Big assets like cottages, again, good conversations will help illuminate whether it should even be passed on to the next generation. Unwanted assets might be better sold now so that money can be used and passed on in a more clean way for the estate. Is there anything else that we didn't discuss, Michelle, that anything else I didn't touch on that we've discussed today?
I was just going to summarize that people think about the assets, the property, the investments, the cash, what have you. And about that, all of this forms together. It's how it's done. And that really forms part of your legacy. And so looking at it very holistically. And I think just this group have tuned in today. So they're like miles ahead of most people.
That's great. I am going to remind people, we also have this binder. We call it our Memento Mori. It is a place where you can keep all of these things like your powers of attorney, your wills, contact information, bank account information. I give this out free to everybody. If you would like one, just please contact me and I'll have Natalie put one together for you and send it out. Otherwise, I'm going to say goodbye to Michelle and thank you again for joining us today. I'm also going to say that April 8th at 2 p.m., which is another Thursday, we will be joined by the lead manager from Centurion to talk about real estate and apartments and why REITs are, a factor in our portfolios. But for today, Michelle, thank you very much. I think it's been really educational. And like I say, we'll upload this to YouTube in the next week or so, but it will be on and people won't know about it. So Fidelity's people the compliance people can relax. So everybody, thank you so much for joining us today. Michelle, thank you again. Again, thank you, Alex, as well for helping arrange this. That was great. Thank you, everybody. Have a good day.